Morning, Councilor Kennedy.
Good morning, Councilor Jubenville.
Councilor Luffa.
Councilor, that's a long time ago. Sheriff. Okay, we're going to get started. Everybody will be wandering in as we get started. I'm going to start by reading a letter from the governor to the Executive Council saying, "Dear councils, I am pleased to nominate the Honorable Cathleen Campbell to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Charles Baker." Okay. Councilor Jubenville is present. Right now, I'm Councilor Terrence Kennedy. I'll be chairing this hearing. The other councils will be coming in as we get going. Why don't you introduce everybody you brought with you, and then we'll get going.
Thank you very much, Councilor Kennedy. This is my husband, Kevin Daly, my mom, Carol, my sister, Kerry, my cousin, Janice, my cousin, Colleen, my sister, Carolyn, you know, Chief Justice Brieger from the Superior Court.
Oh, I do.
Assistant Clerk Caitlin Gilberty from the Salem District Court, retired Judge Ellen Flatley, and retired Judge Bob Rubel.
Great, super. So we're going to call your first witness, which I understand is Judge Luffa.
Thank you very much, Councilor Kennedy. Pleasure to see you and Councilor Jubenville. I actually stood in this spot 9 years ago, almost to the day. I asked you to confirm Kathy Campbell, who I've known for better than 35 years, to the district court. It's hard to believe that 9 years have since passed. Councilor DiPaolo, Councilor Ferrera. I retired last October after 24 plus years of service, 8 years in the district court, 16 years in the, excuse me, 8 years in the district court, 16 years in the Superior Court. And having had that wonderful experience of being a judge, I can wholeheartedly say that I offer my unqualified recommendation of Kathy Campbell, who now is seeking your confirmation to the Superior Court Department. I did meet her 35 years ago. She was a teenager, and she walked through the doors of the Suffolk County Sheriff's Office, where I was the sheriff of Suffolk County, as a John William Law Service Fellow. And I couldn't imagine that encounter would lead to a personal and professional mentorship. I've been her unofficial mentor. I just told Chief Brigger that. And she has absolutely had an astounding legal career, both as a practicing attorney or prosecutor in Essex County. She worked with me as an assistant general counsel, developed sorts of civil litigation and labor relations. She is probably the most conscientious, highly motivated, most professional individual that I've ever met. She has an unbelievable, insatiable appetite for the law. She has a reputation that is unenviable in the district court. I know she's written over 400 decisions. She is thought of, quite frankly, as one of the premier district court judges throughout the Commonwealth. I also know her personally because she's been an active and contributing member of the Alston Bright community where she resides. And I know that she has performed a tremendous amount of pro bono work for the Vocational Adjustment Center, which is a nonprofit agency providing training and placement for special needs adults. She still is active with the Boston Latin School's John William Lloyd Public Service Fellowship. She's an avid runner. She's going to run the marathon with Caitlin coming up in October. She volunteers today as a youth running coach for a program called To the Right Track, which is a youth running club that targets inner city children between ages of 7 and 18, and they absolutely love her. She gets together with them on Saturdays, and I know runs all over the river. I don't run too far at all, but I know that she's an active and contributing member of that particular program. So a few years ago, Judge Kathy Tubman, myself, and Judge Bertha Joseph were asked by then Chief Justice Fabricant to devise a program called Judicial Equanimity. I didn't really know what equanimity meant, but I quickly found out. It means mental calmness, awareness of mind and temper, composure, especially under difficult and stressful situations. And it's finding the right balance for a proper disposition in a case, whether it be a criminal case or a civil case. And I had a ball with that program with Bertha Josephson and Kathy Tubman. and another judge, Julie Bernard, from the district court. And we went out to Worcester and we put the program on twice a year. And it was just an unbelievable experience for me as a participant, and also I hope for the people who did that. Now, why do I mention it? Because this applicant has the complete package of judicial equanimity. She is somebody who I think will hit the ground running in the Superior Court. She can meet the challenges of a very busy court docket, both on the criminal and civil side, which is required. And it is for that reason that I wholeheartedly would ask you to confirm her appointment to the Superior Court. Goodbye.
Thank you, Judge. Before I put the questions to the floor, I just want to introduce Counsel Ferrara, Counsel Marilyn Petito Devaney, and Counsel Paul DiPaolo. Does anybody have any questions?
Not Judge, always a pleasure to see you. Hail from Cape Cod.
I'm a Brighton boy who transplanted to the Irish Court. I wound up 16 years in the Barnstable Superior Court and had the pleasure of having Counselor Jubenville appear before me many times.
Glad that you're in my district now. Thank you for coming tonight.
Counsel Jubenville.
See you. In the Superior Court. The case that I was involved in were some from India,
Yes.
charged with murder. Indian had about 2.5 years.
I remember it.
I think you said they've been here every single time. They've already served a sentence.
Well, we had then First Assistant District Attorney Brian Glennie as the prosecutor, who now is one of our, yes. So that was a fun case. It was a tough case. It was a challenging case.
Wish you well in retirement, and if you need anything at the council, everybody here is receptive to your
I'm
phone.
doing fine. I'm chasing my 2 grandchildren around who are 10 and 7, and I'm enjoying myself and still staying a little bit involved, volunteering where I can to help the court system.
Counsel Devaney.
See you, Judge. And you left me in my district, but I still voted for you. Yeah, you were a neighbor of my cousin Charlie Salucci from Metna Street. That's right. No relation to the governor. Yeah, so your well, retirement was really agreeing with
I
you.
turned 70. They said, your brain's fried, you're gone.
So tell me, what impressed you the most about this nominee?
Just her insatiable appetite for the law. She would call me regularly and let me know when the appeals court reversed me or affirmed me, or the SJC.
It's often.
128. So she just exudes an enthusiasm that's beyond comprehension. She just has this work ethic that is incredibly, I don't know how to put it. She just doesn't stop. I don't know when she sleeps. She just completely immerses herself in her work. I know this from speaking to people in the district court. She has unbelievable legal acumen. She can write. She puts herself on the bench with proper judicial temperament, which is very important. We assume that everybody knows the law that makes it this far through the JNC and the process, but she just has this interpersonal skill capability that is beyond belief.
Thank you. Your testimony means a lot to me. Good seeing you.
Thank you, Judge. We appreciate your testimony. My favorite assistant clerk, Caitlin Gilberty, who's a former assistant DA, currently assistant clerk in the Salem District Court. She's my early morning call when I'm going to Salem to say I'm going to be late, hold everything for me, or I'm not going to get there, so.
Good morning, ladies and gentlemen of the Governor's Council, Judge Campbell, and the friends and family of Judge Campbell. My name is Caitlin Gilberty, as I've already been introduced. I'm currently an assistant clerk magistrate in Salem District Court. I met Judge Campbell back in 2012 as an assistant district attorney in Lynn District Court when she was first appointed to the bench. I practiced in front of her until 2018, and by that time, I tried numerous jury trials and bench trials, litigated numerous motions, and likely hundreds of 58As in front of Judge Campbell. Over the years, Judge Campbell has become a mentor both in my professional life and my personal life. She has encouraged me to gain every experience that I possibly can in order to obtain a diverse skill set, both inside and outside of the courtroom. When I left the district attorney's office, I was petrified. Judge Campbell assured me that it was going to benefit me in the long run. Speaking of runs, when I signed up for the Boston Marathon with almost zero writing experience, she has cheered me on every step of the way. If I had to think of one word to sum up Judge Campbell, I honestly couldn't think of just one. The words at the top of my list include fair, just, thoughtful, and kind. Fair in the sense that, although I think I was one of her favorites, I didn't always get my way. Judge Campbell's knowledge of the law and application to the facts in front of her was better than any evidence class that law school could have offered. From the admittance of certain evidence at trial, like expert opinions, first complaint testimony, to the applicability of protective statutes like the rape shield law, Judge Campbell's knowledge of the nuances in the law truly helped me to become a better trial lawyer. But Judge Campbell went beyond what is fair. She is just. Fair is that technical application of the law to the facts. Just is what is ethically and morally right and cannot be accomplished by simply just knowing the law. Judge Campbell taught me that what happens in that courthouse and in those courtrooms has a direct effect on the communities that it serves. And Judge Campbell clearly cared about the community, not just by her actions on the bench, but by her volunteer efforts. One of my favorite experiences with Judge Campbell was participating in food prep at Brothers Deli in Lynn the night before Thanksgiving to help provide free turkey dinners to the community. Another would be the Clock to Rock 5K in Lynn, which supports arts and cultural programming in the city. I have a small side story about this 5K. It was my first time running 3 miles, which was a lot to me back then. She showed up and said she was going to take it easy, that she was injured. Come to find out, she won the whole thing. First place. In any event, Judge Campbell very much cared about the community. She often reminded us that at the end of the day, we as the lawyers, we get to go home to our lives. But the people involved in the matters before the court, the defendants, the victims, the witnesses, they have to live with the decisions that are made in the courtroom. Everything isn't black and white, and it's important to take into consideration more than what can be determined from a police report or board of probation record. Which leads us to thoughtful. In an effort to achieve a just outcome for every case, Judge Campbell truly put thought into her decisions, verdicts, and any sentences imposed. Every victim that walked into that courthouse had a voice. Judge Campbell would take the time to listen to what each victim had to say. She would ask them questions, and she would try to determine what impact her decision would make on their lives beyond the courtroom. And this is what makes her kind. Kind is something that is beyond courteous. It did not matter if you were court personnel, a lawyer, a defendant, victim, witness. Anytime you were appearing before Judge Campbell, you always felt seen and heard. She is understanding and compassionate and acknowledged that although it may be a normal Wednesday for the court, for the people appearing before her, it could be their worst day. She always took that extra time out of her day to acknowledge each and every person in their individual situation. And for me, this extended beyond the courtroom. In 2018, I went through 2 surgeries and a round of radiation for thyroid cancer. I received a card almost every week from Judge Campbell during that time. She bought out the paper store. Having a single one of these traits would make Judge Campbell a great judge. It's the combination of them that make Judge Campbell unique and truly an asset to the bench. I'm honored to be here today to speak on Judge Campbell's behalf, and I'd like to thank the Governor's Council for this opportunity.
Thank you, Caitlin. Before I open it up to questions, I just want to recognize Counsel Eileen Duff, who was on WebEx. And I also wanted to recognize Judge Matt Mashera, presiding judge of the Chelsea District Court, who was on WebEx. Does anybody have any questions of Counsel Devaney?
Thank you for coming. You know, it means a lot to me to have someone that knows the nominee on a day-to-day basis. I've said it before, but it just, to me, it's incredible that nominees in the past have brought someone to be a witness and said, you know, what do you know about this? How long have you known? I saw him once in court. That doesn't do it. Your testimony was from the heart, and I appreciate that. When you look back, is there one case that she was involved in that really impressed you above all? That's a pretty hard question, but is there something?
The district court was such a busy place and so many cases. I would say, so I was on the domestic violence unit for a long time, so I primarily handled domestic violence, sexual assault, child abuse cases. Any child abuse case that I had, this is my other favorite Judge Campbell story, she would have a basket of stuffed animals in her office. And anytime I brought a child into the courtroom, she would close the courtroom. She would take the time to speak to them. Because, of course, the courthouse is a stressful place, but she really made it the best situation it could be for any child that walked in there.
I'm not surprised. I voted for her 9 years ago. But your testimony means an awful lot to me.
Thank you.
It really does. And the one adjective you didn't use in talking about her was compassion. And I don't vote for anyone if they don't have compassion. And you obviously saw that too. So thank you. I appreciate you.
Any other questions? Thank you, Caitlin. Get your application together. I think it's gonna get through.
Thank you.
Okay, that completes the nominee's witnesses. Is there anybody here in opposition to the nominee? Thank God the State House is closed. That will close that part of the hearing, and it's your turn.
Thank you very much. And thank you, Counselor Kennedy, for the opportunity to introduce everyone who has come here with me today. Of special note, though, I do want to point out Judge Ellen Flatley. She is the first female ever appointed as a district court judge in Essex County. She also is the first person who I ever tried a jury trial in front of more than 25 years ago in the Lawrence District Court. And it really means a lot to me that she's here today on my behalf before the Governor's Council. Counselor Kennedy and members of the Governor's Council, words cannot express my gratitude to you for conducting this hearing today, and my gratitude and appreciation to Governor Baker and Lieutenant Governor Polito for nominating me to the Superior Court. I know Counselor Kennedy, along with various other practitioners, as well as staff at many of the courts where I serve, tease me. They tease me because of how often and how many times I say thank you when I preside over the courtroom. One day, a probation officer in Dedham decided to count thank yous during the morning session. It was more than 200, to attorneys, to court staff, to members of the public who came before the court. Why? Because even after 9 years serving as a district court judge, I remain so humbled and incredibly grateful for the honor and the privilege to serve the people, all of the people of the Commonwealth of Massachusetts as a judge. My 4 grandparents were all immigrants to this country and became naturalized citizens. My father, a proud member of the Massachusetts State Police for 26 years. My mother, after raising my sisters and myself, worked as a teacher's aide. Not only did I hit the lottery as a woman born in the United States, I hit the trifecta the day I was accepted to Boston Latin School, graduating as a member of its 351st class, but only the 10th class to contain women. Without the Boston Latin School John William Ward Public Service Fellowship, which introduced me to people like Sheriff of Suffolk County previously and retired Superior Court Judge Bob Rufo, I would not be here today. Our lives really are a book of stories, and I'm going to share a brief one. My daughter Carly could not be with us here today because she's studying hard at Amherst College. She was writing essays recently for an application to medical school, and one of her essays started like this. I began to volunteer in my community before I could walk. My mom would carry me in an infant carrier to meetings for the Vocational Advancement Center and other area organizations. The Vocational Advancement Center doing advocacy and job training for special needs adults. As I grew, my volunteer responsibilities to my community grew. I think my children, Alex and Carly, believe that life is one big public service project, and I would have it no other way. Because to whom much is given, much is expected, and one must always act as if you can make a difference in the lives of others. In closing, I make you only one promise, and that is if you find me worthy to serve on the Superior Court, Each and every day, I will work collaboratively with my fellow judges, be committed and passionate about doing justice, serve with honesty and integrity, and do everything in my power to make you proud of the faith that you've shown in me. Thank you.
Thank you. I just want to acknowledge that Counselor Hurley is on WebEx as well.
Excuse me, did you say that Judge Machero, because he called me, he was going to speak?
I don't believe Judge Machero was going to speak. I know he wanted to be on it. He's welcome to.
Well, that's what he said on the phone, he wanted to.
I'm on. I
Then
don't know
he
if
went
you
to
can hear me. I am on.
Judge Machero, did you want to say anything? You're welcome to.
I'm on.
Only if it's good, though.
I find myself a.
Depends on what you're
Well,
going to say.
no, it's not going to be good. I find myself. Can you hear me, Counselor?
Yes.
I
hear
find
you, but
myself
how
in
should
a
we want-
difficult position because I don't want Judge Campbell to leave, so I don't know that I could say anything good about her.
We'll
It would be
make
like
sure she
trying to
stays.
replace 3 judges.
All right. Thank you, Judge. We appreciate your comments. With that, I'm going to open it up to questions from the council. We're going to start with Councilor Ferreira.
Thank you. I have no questions. Yeah, you and I had a nice conversation. Counselor Kennedy, when you first nominated, grabbed me and said you were the best of the best on the district court. My comment to you was, I'm not sure why you want to work harder and more, but God bless you. Thank you for your service, and I'm sure you're doing a good job at the Superior Court.
Thank you.
So Jubenville.
Thank you. I've had the pleasure of being before you, and I have to say you that one bit. You were very kind and compassionate, and your advocacy for those less fortunate is outstanding. I do have a couple of, they're not really questions, but my favorite topics that I'd like to get into now and then. You're going to go to a court that uses guidelines. What do you think of guidelines?
Well, I'm very familiar with the guidelines for sentencing in the Superior Court because I served on the Massachusetts Sentencing Commission from 1994 to 1995. So I was part of the research committee that helped to get the information that was used to first formulate the guidelines. I think that the guidelines are a good starting point, but because they allow us to take a look at both the individual's record and the seriousness of the offense and find out a particular range where sentences normally are. But as you know, Councilor Jubenville, the guidelines provide for the consideration of both aggravating and mitigating circumstances. And therefore, they are just that. They are guidelines. They are not necessarily definitive as to what a sentence should be in a particular case. We have to look at the whole entire situation that brings someone before the court.
Well, you're familiar with the federal court in the sense that they've used guidelines for years, right?
Yes.
And I don't think anybody would disagree with me, even some U.S. attorneys, that they were draconian. They hurt the citizens of this Commonwealth and this country tremendously. With severe penalties of 20 years for possession of marijuana back in the day. So why would we ever adopt a system that was so flawed and mean-spirited to the citizens of the Commonwealth in our Superior Court?
Well, the guidelines are discretionary. They certainly are not mandatory, and we as judges have the ability to take into consideration absolutely anything in formulating what we think is an appropriate sentence for someone who appears before us, of course, unless it involves a minimum mandatory, which in many cases ties the hands of the judge that an individual comes before in terms of a sentence that can be imposed. But I think what the whole reason why Governor Weld developed the guidelines associated with truth in sentencing was to allow the situation to be more understandable for the public in terms of how things worked in the court. So, and also, as you know, in order to bring kind of truth back to sentencing, because at the time that Governor Wells put in place the sentencing guidelines, as you know, there were Concord sentences where a judge would announce in court someone was receiving a 20-year sentence and they would be out in 2 years. And that was something that was affecting the public in a negative way, and that they would be wondering why people were back out on the street in such a short period of time after receiving a sentence. So I think that was part of the catalyst for putting in place the guidelines. But as I said, they're just guidelines, and there are many, many aggravating and mitigating circumstances that can be taken into consideration in terms of a sentence that would be imposed in a particular case.
So with all due respect to Governor Weld, he was a assistant U.S. attorney for a number of years. He grew up in that system and he liked that system. Not too many people like that system or like that system. So the federal system was designed to make it sort of equal across the country on sentences. Somebody's charged at a particular time in Boston and at the same time that somebody in San Francisco is charged with the same crime. But I suggest that was a fool's errand. It never worked. And it's never going to work in our courts if you use the guidelines, in my view. The same person charged in Suffolk County, it doesn't fit that the same person in Pittsfield should get equal sentences. I know they're guidelines, and I know they're not adopted by the legislature. The legislature is the only recognized body that can vote on what's a crime and the punishment for that crime. Nobody in the Superior Court has the power to do that. Yet, they're starting points. I hear it all the time. I'm in the Superior Court a lot. I hear it all the time. Oh, Judge, the guidelines say 5 years. Now all of a sudden it's sort of gospel. That's where we're starting from, up or down, which I don't think is fair, number one. Number two, Judge Harrington in the federal court, a wonderful judge. And he got so disturbed over the guidelines that he refused to sentence anybody on the criminal side of the court under those guidelines. And he made it public. And he said that he was going to use what judges have used forever. The defendant's crime, the record, aggravating factors, letters in support of a defendant, all the things that judges did for 200 years without guidelines. I know you haven't, and I haven't, ever seen a case sitting on the clerk's counter that's, let's say, 10 years old, and I say, well, how come this is, well, we don't have the guidelines. We didn't have the guidelines, so we can't sentence anybody. I don't think they're fair. I think they are much burdensome on the minority communities of this Commonwealth for a lot of reasons. So I know the court seems to want a one-size-fits-all, but I don't think that's should be done. So anyway, that's my take on that. So if I'm in your court someday and the guidelines are mentioned, I'll go off on my rant. Okay?
I would just mention one thing associated with that, because as you point out, and it is really true, there's a tremendous amount of disparity in society, and people who live in communities, including minority communities, are overrepresented in our population that comes before the court and our inmate population that exists here in the Commonwealth of Massachusetts. But I would just note that one of the mitigating circumstances under the guidelines, and one that I certainly would look at depending upon who came before me in the court, is that they indicate that one of the circumstances you should take into consideration is the defendant's residence in a poor or minority area with deep police penetration, which causes overstatement of the seriousness of the criminal record. So that is literally a mitigating circumstance under the guidelines to be taken into consideration by a judge when they're looking at an individual who comes before the court. And it certainly is something that I would
I've never heard a judge say, okay, this defendant grew up in Roxbury or Holyoke or Springfield, and therefore I'm going to reduce the sentence because where he lived. I never heard that said in a court by the judge, or I never heard it said by an assistant DA, and I've never heard it said by a defense lawyer. But my view is they fall more heavily on the minority community. And let me just comment once. I think that Governor Weld, although he wanted to change the system, did a big disservice to us in the Commonwealth by changing the sentences, the Concord sentences, the state prison sentences the way he did. And I'll tell you why. I think the problem was the court did not educate the public as to what was going on with a Concord sentence. Concord sentences were for first-timers, first time charged with a crime, serious crime. And so the idea was, the judge said, if I give the fellow 5 years in Concord, he'll serve 6 months. 10 years, he served a year. 20 years, he served 2 years. Then he would be paroled for the balance of that sentence. So on a 20-year sentence, he'd be on parole for 18 years, reporting to a probation officer, a parole officer. So the idea was give the first-timer a taste of what it's like to be in jail, and then we'll put him on parole. And hopefully that being in jail prevents him from committing another crime. But I don't think we were effective in getting that to the public. The other thing that changed was the state prison parole eligibilities. Before he changed it, if you were convicted of a felony, let's say the sentence was 6 years, well, you walked in 1/3 of that sentence you could get good time for when you walked in. So that would be 2 years. So the person would have to do 4 on the felony. On misdemeanor, it was 2/3. You walked in with credit. Those were credits in your bank to get out of jail. First of all, what it did was it kept inmates in line because they didn't want to lose those credits by misbehaving. Correction officers never liked that change at all. It handcuffed them. When somebody's doing a 6 or 6 in a day, they can do whatever they want. You can punish them in jail, but you can't stop them from getting out. And when they get out, there's no safety net to take care of them because they're released to nothing on a 6 in a day sentence. So the Concord sentence and the state prison sentence, I believe, had a lot of good effects to it. One was, the other thing they changed was a judge couldn't give a suspended state prison sentence. So I don't know why that was. I haven't looked at the literature on who thought of that. But in any event, we went to a much more draconian system that has caused uptick in the number of inmates that sit in prisons, again falling heavily on the minority communities. So I don't think it was a good idea, but that's my opinion. Governor can do what he wants. You've read the report on racism in the court system?
Yes.
The amount of discrepancies between incarcerations and minorities and whites.
Yes.
Why do you think that happens?
Well, one of the nice things in that report is they didn't find the same sort of discrepancies in the district court as they found in the Superior Court, and that certainly did my heart a little bit of good, and that I think of my colleagues. The discrepancies in the Superior Court, I really can't place my finger completely on why. And
Well, one thing I would suggest is they're being sentenced to prison by a judge. So judges throughout the Commonwealth are putting people in jail. That's how they get there, right? Okay. So there's a big uptick in the amount of minorities compared to whites, the percentage. So how do you as a judge deal with that issue? Because it's pervasive, not only in our court system, in my opinion, but throughout all of our systems because of the way our country has developed over 250 years. So and it's built into the court system also for all these years. So how do you factor that in if you're on the Superior Court, which you're going to be? How do you factor that in so that you don't keep contributing to the discrepancy?
I think that one of the things that you do is really, every time that you're in the court and you have someone before you, you try to do a check associated with any explicit or implicit bias that might be involved in the situation that brings someone before the court. The district courts, as you may know, in the last few years have even changed their jury instructions that they give to individuals who are sitting as jurors and instruct them to check their implicit and explicit potential biases associated with the situation to make sure that those aren't being taken into consideration when they are doing something in terms of ruling as a juror. And I will tell you, I went to a presentation with Chief Justice Kim Budd, and at that presentation, she said that she had a poster hanging over her area at the Supreme Judicial Court that had been given to her by Justice Ireland, and that with every single case that came before her, she takes the time for a moment to pause and say, am I doing justice? And that was a very big teachable moment for me to be at that presentation that she gave. And I frequently on the bench, before I rule associated with a situation, use that as a check to say, am I really doing justice in this case? Because at the end of the day, that's what we want to be able to do. And I think that those are the type of things that judges can do to try to make sure that they are taking into consideration all the different factors in an individual's background and trying to figure out what the appropriate disposition of a case should be.
Trials since the pandemic in the district court?
I have not. I've done several bench trials, but no jury trials in district court since the pandemic.
I'm going to start one on Monday. But here's a question for you. Sitting in the Superior Court jury trial, do you make the witnesses put masks on?
In every case, I've done several bench trials in the district court. I ask the witnesses to take their masks off. The witnesses are at least 6 feet away from absolutely everyone else in the courtroom. And it's important to me that their facial expressions and what they have to, their body language can be seen by people in the courtroom, and I want to see it myself. So in bench trials that I've done since the pandemic came about, I have required that people take off their masks when they are testifying. We have the court officers go over and spray down the plexiglass and the area where the individual was sitting before anyone else can come in and sit in that spot in order to give testimony. But I think it's critical in a case, and I would, unless there were some incredible reason why someone could not pull their mask off, I want their mask off.
What about jurors?
Jurors, that's kind of an interesting question. I haven't had a jury trial go since the pandemic came on. And as you know, the jurors tend to be a little bit closer to one another. And I don't know that I would necessarily want to put a juror in a situation where they felt that they were exposing themselves to COVID by requiring that they take their mask off. But quite honestly, I would hear what the attorneys had to say associated with that situation and take it into consideration. To me, It's like when I'm doing a jury trial and attorneys come in with recommendations for voir dire questions for the jury or other things that they want in the courtroom. I'm going to talk to them about those situations, and it may be a situation where the jurors are comfortable taking their masks off, in which case I would want them to have their masks off, because as you know, as someone who works in the court and practices in the court, facial expression and people's responses to what you're saying is critical to your ability to be able to adequately represent your client.
Let me just ask you this, the district court, when somebody does a plea, they fill out a green sheet, put down what they want, the DA puts down what they want, and the judge, and if the judge doesn't accept the defendant's plea, then he doesn't have to follow it. Not so in the Superior Court. Usually judge will say, well, I won't go over the Commonwealth's recommendation. Lately I've been thinking, why do they get the preference? In other words, why isn't it like the district court? You fill out what you want, and the judge either says yes or no, or tweaks it in one way or another. Why does the prosecutor get to the high-end number, you know, because they can say whatever they want. Judge, I want 10 years on this guy. Oh, they won't go beyond the 10 years.
Let me just say, Councilor Jubenville, people who have come before me, especially individuals representing individuals, for instance, on a probation surrender, where that's the standard, right? If someone's on straight probation, I can impose anything up to the maximum penalty associated with the case, or I can go along with the prosecution's, the defense recommendation. I have to tell you, in 95, at least out of 100 of those cases that come before me, I have the attorneys up at sidebar, and we discuss what I'm going to do before I allow them to enter into a stipulation. And I frequently say to the individual who's in the dock, this isn't a game about what's behind door number 2. I want things to be upfront, and I want you to know what's going on here. I have had a conversation with the attorneys. This is what I said I would do in terms of a disposition. You understand that, because I don't like games. I just don't like it. I don't like that. And that's not the way that I have practiced as a judge in the district court.
So, yeah, there are judges that you go to sidebar in the Superior, and they listen, and then they finally make a decision at some point and tell you what they would do, which is great. But some don't. Some say, I won't go over this. So they leave it up in the air.
I don't like that.
I don't either.
think that's fair, because I don't think as an individual, and I've been on both sides as a prosecutor and as a defense attorney, I don't think it's fair to the defendant, and I don't think it's fair to their attorney to conduct the situation in that fashion. I just don't. I think that people should know up front. That's kind of, in my opinion, the transparency associated with the court, which is so incredibly important. So I don't play that game.
Well, when I first started practicing, there was no rule about the sentencing. So what you do is usually have a lobby conference, and they still do them in some counties. I've never heard anything inappropriate said in a lobby conference. There's usually an assistant clerk in there and a probation officer in there, and sometimes even a stenographer. But it was a great way to resolve cases. And if there was something embarrassing on behalf of a client that you wanted to say, but not in open court, we got a chance to say it, and vice versa for the DA. So that's nothing. But you ever hear of the Alfred plea?
Oh, yeah.
They're doing more of them in the Superior Court. What's your feeling on that?
I haven't really given it a tremendous amount of thought at this particular time. I certainly, even in private practice, though, have had a client who has tendered an Alfred plea to the court. So it's certainly something that I would take into consideration. I'm not against Alfred pleas. As I've indicated, I offered them on behalf of my own clients when I was in private practice.
Yeah, I forgot to say, on the plea situation, when I first started, the judges would, you go in the lobby, the judge would tell you what he's gonna do. Let's say 3 years, he's gonna, okay. You plead. The DA read a statement of facts. And it happened to me more than once. The judge said, oh, well, I didn't realize that. Now the client's already pled. So therefore, I'm gonna give you 5 years. That was not uncommon back then. And I think it's the reason why they went to a system where you either tell or you put some parameters on it. Because obviously, if you tell your client you're going to get 3 years and he pleads, and then the judge says, oh, well, this is a lot more serious than I thought, I got to now give you 5, it makes for an uncomfortable situation and unfair. That's all I have for you, my little issues. Anyway, I think you're a wonderful candidate, and I said that to you on the phone. Judge Machera called me also much. And I am going to be voting for you next week.
Council Devaney.
Thank you. Before I question the nominee, I'm curious about who our guests are.
She introduced them all at the
Did she
beginning.
introduce them?
She did.
Okay. Thank you for all the time. This is the second time in 9 years we met at the diner, and my one regret is that you're not in my district. They have split Austin every which way, and I was so hoping that, that I would be presiding. But my colleague is had it as 3 of us out of that area. But anyway, I just, I don't have a poker face, and I am just so happy that you decided to go to the Superior Court. What made you decide?
It was a really hard decision because I love my colleagues on the district court and I love being a judge. But I also, before I joined the district court, had done a tremendous amount of appellate and some incredibly challenging cases, and also had handled some civil cases before the Superior Court in private practice. And I think that this is an absolutely wonderful opportunity for me to grow as a judge. And also, both of my children are getting ready to finish up college. My daughter is a junior. My son is in his senior year in college. They couldn't be here because they should be studying hard. At least I hope they are. But it's now at the point where they're getting ready to go off and to live their best lives. And it's an opportunity for me to take on new professional challenges and to just kind of have something else that will help to occupy my time now that they're kind of moving in another direction. So I just felt it were the right time for me to explore this sort of opportunity.
Councilor Ainella just came, and I think that we're the only ones that were here 9 years ago that voted for you. And I was so impressed. And we were so impressed, and I'm just as impressed now. And I am so thankful that you decided to go up to the Superior Court, because we need you. This council voted for someone with 6 cases in 21 years in the Superior Court. That certainly isn't enough, and that's why I want to see someone with I want to clone you, because I want people like you to be judges that have the age, that bring life experience to the bench, to have experience and all the qualifications. You don't see that when you have someone 4 years old or that in that area. So I can't tell you how pleased I am. I usually don't say this, but I can't help it because, we met, I know you so well in those 9 years. You talked about your family briefly, but tell me about your dad. He was a state trooper.
He was.
Lost him very young.
We did. He served on the Massachusetts State Police for 26 years, and he absolutely loved his job. I only saw my father shed a tear once, and it was the day that he hit mandatory retirement age at age 50. He was so proud of the work that he had done on behalf of the Commonwealth. And my becoming an attorney is in large part because of him, because when I was a little girl, he used to talk about Alice Richmond and Sydney Hanlon, who were assistant district attorneys in Suffolk County when he was working as a state police officer. And he was so impressed with them and their skills. And he really is the one who put the seed in my mind that maybe I might like to be an attorney. I suppose I aspired to be like them because he just held them in such high esteem and enjoyed working with them so much and thought them to be just such honorable and professional women. So unfortunately, my dad passed away of a heart attack right after he was to retire at age 50. My sister Carolyn and I were still in college at that point. My sister Kerry was 15 or 16 years old at the time. My sisters, my mother and I circled the wagons and said, you know, we've got to do everything that we can. I'm incredibly proud of my sisters. My sister Carolyn is a nurse. My sister Kerry is a CPA and vice president of Delaware Life. And we just gathered the wagons, put the nuclear family together and said, we've got to do what we can to kind of move forward. It was not an easy experience. We lost a lot.
Yeah.
When people come before the court and they are in a bad spot, we weren't in the best of spots then. I mean, right down to the fact that my older sister and I shared a Chevy Stevette that we used to drive back and forth to Northeastern. And when my father passed away, we had to get rid of it because we couldn't afford to keep it. And I was an attorney working for Bob Ruffo for more than a year before I could afford to get another car. So, I mean, it was not an easy experience, but he had a huge impact on my life. He honorably served this state, and you know, I'm so incredibly proud to be his daughter and to have had his influence in my life.
Well, who's proud of and your family? I know that it feels like I lost my dad 56 years ago. So, but I thought you should tell that story because that makes you part of it. I want people out there to know you were involved with a silver spoon in your mouth, and all your relatives aren't on the bench, and you earned it the old-fashioned way. And I don't mean to be a cheerleader. I usually don't talk like this, but you know, I know you so well. And as I said, voting for you 9 years ago, I got to know you so well. So I was impressed then, as I am now. Now, just to put it aside, the sentencing guidelines, I heard so many attorneys don't like it. Now, right now, you know, after 25 or more years of the sentencing guidelines, is there anything that you think should be changed? That's something that you thought, well, we should rethink that.
Well, I definitely think that mitigating circumstances are something that constantly change. And I know that Counselor DiPaolo is very aware of the considerations of age and mental development associated with age in terms of the things that are important for him, for the court to be thinking about and focusing on. And I think that the guidelines could have more in there associated with mitigating.
25-year thing, is that what you're talking about?
I'm sorry.
Are you talking about the 25-year age? Is that what you're talking? You said age.
No, in what I think that some of the things that the sentencing guidelines don't give enough credence to are, for instance, individuals who come before the court with mental health issues, individuals whose brain development may not be what other individuals are. Those are things that I think are really important for us in terms of a holistic approach to how we see the individual. And I think that's probably one of the biggest shortcomings associated with guidelines, right? Because they don't take into consideration all of those factors. But to me, guidelines are guidelines, right? They don't rule the day. And I would just use one particular example. I had a case over in Malden where a young man was charged with carrying a firearm, an 18-month minimum mandatory. He had taken his father's firearm and gone out into the driveway of the house and tried to blow his head off. He was unsuccessful. They took him to Mass General Hospital and they treated him medically, and then he spent 2 weeks in the psychiatric unit there. The district attorney's office would not move off the 18-month minimum mandatory associated with that particular case. The young man had almost no record before the court. He was in mental health treatment. It was going to be an insanity defense. I was handling that case as the judge. He was willing to take a plea of 2 years in the House Correction, suspended for 2, with continued mental health counseling and medication. He was back living with his parents and on psychiatric meds. I went to the district attorney's office and I said, I'd like you to break this down in order for us to be able to impose a non-minimum mandatory sentence. And the ADAs in the district court did what they're supposed to do because they don't have any discretion at that level. They said, no, we can't do that. And I said, well, get your supervisor for me. So we had another meeting and I met with the supervisor and we actually had an in-chambers meeting. The only in-chambers meeting that I have done without a recording was in this particular case. And they said, no, we really can't do that. I said, well, no, you need to take this all the way. I don't care if you have to go up to the district attorney of Middlesex County, Marion Ryan herself. The only thing that I'm going to accept is that you've run it all the way up the flagpole and that she herself is saying that she will not reduce this down. And then I'll accept it and then we'll go forward with the insanity trial, which, as you know, involves having to do individual voir dire with people when they come in, complicated situation. District court instruction on insanity wasn't even accurate. I had done the research to find out what was wrong with it. Going forward to trial, finally, the district attorney's office conceded, and that case pled on 2 years suspended for 2 years with ongoing mental health treatment and with counseling and medication. And you know what? That's what justice is all about. And that's what my job is, in order to look at a case and say, look, what we need is justice, and to try to put the pressure in the right direction in order to be able to do justice.
No, you've had, well, what I really like about your experience is that you've had 60% criminal, 40% civil. That's important to me. I think especially in our society now, we need people with strong criminal background. I have a philosophy. If you have an attorney and they're appointed as a governor, as a judge, and when they were an attorney, that person never had criminal cases, I believe that that judge would be timid in giving the right decision in sentencing because they never had any experience in representing either way. You agree with that? You don't have to, but I mean, that's my feeling, that you need to have that experience to bring to the bench.
I certainly think that that's important, but I would just say that, especially not as much, I don't see this much on the Superior Court level, but on the District Court level, we sometimes have people who are professionals either in civil or criminal, not as many who have both when they come in. And I am incredibly impressed with the ability of the judges to learn associated with, especially in the criminal arena, because we get a lot of people, as you know, because you approve them, that come from like the Department of Industrial Accidents.
Yeah, no,
and they don't have any criminal experience.
Yeah. No, I see that, but I'm talking about where you're going in the Superior Court. They're sentencing, and that's the difference with the District Court. What do you think for you, with your experience, and I love it, 33 years, I couldn't ask for more, and I love it. I love private practice. I like it because you chose who you want to represent. I mean, we've got people that are great, district attorney and attorney general's office, but they're given the case, and the police give them half of it. They're halfway there. But you choose who you're going to represent, and that to me means a lot. And so the other thing is, you know the responsibility when that lawyer comes in with a client. He has to pay the rent, he has to pay, he has to shovel the snow, all of that. And I think that the judge has a different feeling when he sees a client coming in with a lawyer. And I know everybody comes in at 9 o'clock, but maybe you can, adjust it so that you get this person out because they're paying a lot. the client's paying a lot. So I just, that's my own philosophy in my 21 years that I have seen. The other thing is, in my 21 years, I haven't seen the things that you brought up about, what's important in the court system. And I think I know you have all those attributes too, that you have worked with people who have mental issues and drug issues and all of that. And I think that's important. And you know what I loved? You said to find solutions. It isn't just ruling. What are you going to do about it? What are you going to do about this person, So, I'm very, pleased with that. I mean, I just think, you've had, in the criminal side, you've had murders and rapes and robberies and drug distribution and child abuse. I don't even know how you deal with the child abuse because it's happening more often. Our society has gone, I don't know, a mother is not a mother anymore, they're killing their children. It's just, I don't know what's happening to our society. But tell me what the most, what child abuse case that you've had that came to a favorable resolution for you, that you interceded in that result.
Let me just say that I think that child abuse cases, especially being a mother, are one of the most difficult that I deal with on the bench, because all of us are human. We have emotions that exist, and it's, especially as a judge, it's incredibly important to see the facts and circumstances associated with the situation for what they are, and to take your, in many cases, your personal feelings and take a step back from them. And I think that that's probably one of the most important things that we do when we have a child who's before the court. But as Caitlin has said, when she had cases and when I was known in Lynn as the teddy bear judge. I think I gave out over 500 teddy bears there because
I thought that was Judge Nestor.
it all started with a little boy coming in with his mom when I was first a judge, and I brought her up to the sidebar because it was a restraining order case, and I didn't want the little boy to hear the things that she was telling me had happened. And he was sitting in a bench by himself, and he could have been 4 years old, and he had his head down, and it was one of the most sad things that I ever saw. The boy was probably about 4 years old at the time. And anyway, so I went to the first justice, Burke-Conlin, and I said, would it be all right if I got teddy bears and I gave them out in the courtroom to the little children that come before our court? Because I'm limited on. And he said, yes. And I said, well, and I want the court officers to present the teddy bear to the children because they're in uniform. And I think one of the hardest things for children when they're involved in a situation is sometimes they don't have trust in people who are part of the system and they're in uniform. And I want the court officers to give them to them. And so we started a little program over there, and I bought teddy bears at the dollar store. But now that I'm in the running club, my kids donate their.
I mean, that's your compassion, and that's why I voted for you before, and you're here again. And the thing is that, you show your compassion in so many ways, even to the people that you work with. And people don't know out there that because of the pandemic, judges are at home, not you. You wouldn't stay home. Why? Because you figured all the people working in the courthouse would have to be emailing you and sending you all the stuff. To save them all that trouble, you were in there every day. That is so impressive that people out there should know. This is dedication. This is caring about the people that are working in there. This is for justice, because everything has been delayed. The Supreme Court jury, I don't think they have met yet. I still don't know. But I mean, it's been a horrific time. But what you have done, you haven't stopped the justice system in your courthouse at all because of that. And I've been talking about your courthouse. I do want to say that when Judge Matera called me, he was so disappointed, he doesn't have anyone to cover to come here today. So I do want to say that, but he couldn't say enough about you. You know, he said, I almost should talk in opposition because I don't want you to leave. But no, it's a great courthouse. I love the drug court. I've gone to the drug graduations. I sit and cry in the back to hear these people who have gone through it, all ages, addictions, alcoholism. And when they talk, I mean, it just touched my heart how it affected them. So I'm learning to see the specialty courts. For you.
The specialty courts, I think, are an incredible addition to the court. They didn't really exist very much when I first came on the bench 9 years ago. But the drug court, the veterans court, the mental health court, they get a mental health court over in Chelsea as well, are courts where the judge can really get the individuals that come before the court. I want to say the downside of that is the emotional toll that it takes when something happens to someone. I was the backup drug court judge over in Lynn for all of the years that I was there. Judge Luffa was the one who oversaw the drug court. But you really get attached to the people whom you work with, and they get attached to you, and that allows you to offer them specific guidance and to get them to really think about their life choices in a way that they might not have previously. But it also has an emotional toll on the judges when we get involved in situations associated with that, because when something happens to someone, a little piece of us goes with them. But I just think that the specialty courts have been an incredible asset to the court. When I was over in Lynn with Judge Flatley and Judge Lamoth and Judge Conlon, which was, I just absolutely loved it over there. I did a lot of our mental health cases, and the continuity of having the same judge deal with those individuals over and over again was incredibly helpful to their ability to be able to work through the problems that had brought them before the court. So I see that as an incredible positive for the court system.
Well, I would ask you, as I've asked other nominees, please lobby the legislators. We need money for more drug placement, because a weekend doesn't do it. I had 2 friends last year who lost sons of overdose of heroin, and they tried, but there's no long-term placement. And I haven't checked this year, but it used to be like 1.5% was going to the judicial and in the budget. So I wish that, you know, your judges would get together and lobby and tell them how important it is. We certainly haven't won the war on drugs, and it's getting worse and worse. And it hits home. Before, it didn't matter if it was in Lawrence or Roxbury, but now it's out in the suburbs, and now people are paying attention. But we still haven't addressed where we put them. What's your opinion about minimum mandatory sentencing?
Well, I just spoke about the individual with the mental health issue and them trying to put a minimum mandatory in there. I happen to be working for Judge Ruffa, who was then Sheriff of Suffolk County at the time. Many of the minimum mandatories were put in place in the early 1990s. They had a very adverse impact on our inmate population, and almost immediately. Over at the House of Correction at South Bay, our individuals serving a sentence for drug-related crimes immediately went up over 40%. And those were mostly individuals from minority communities who were being adversely impacted by minimum mandatory school zone cases and the like. And so we saw the impact immediately associated with many of those. So I'm not someone, I understand why they're put in place and why they want them, but they just are not a good idea, in my opinion. That's just my opinion. I have to apply the law the way that the law exists.
But you know, I believe that a judge should have the discretion, and it takes the discretion away. And I got to tell you, it's very upsetting to me that we have no pardons in this administration. Not one, none. And I think we've had maybe 6 before. And, you know, we credit Well for that. Well was the one that stopped them, wanted to be hardened crime. So you go after the wrong people, Governor Well. And so no one wants to pick up and be the one to do it. And so we've only had a few. But I want to go back on that mandatory, the minimum mandatory. We did have a pardon. The only one was Counselor Ianella and I were there, and this was, I don't know, maybe 7, 8 years ago. That's the last time. And I think of that man all the time, and I wonder how he's doing. Very nice man, about 56 years old. And had gone through a lot in his life. He had cancer, he lost a leg. He said, you know, a lot of things happening to him. But when he was 17, he was on his way to school. And he was a good kid, naive. Evidently, he was gullible. And a 21-year-old friend stopped him along the way. And he asked him if he would sell these 6 bags of marijuana, $25 each. And he wanted to please his friend. That's all he wanted to do. It was the wrong decision. And you know the school law, so many feet from the school. He went into the school and he sold 1 bag. He tried to sell another bag to a student, and the student refused. Brought him to the principal. They found the rest of the bags in the locker. When I first started, it was 5 years. It's 2 years, the sentencing. But I believe at those days, because that was a long time ago, I think it was 5 years. Here's a young man who made a dumb mistake. So that meant he gave up his youth, the dances, the proms, sports, maybe getting a scholarship, college, everything was gone in his good name. So when he came out, he was fortunate, he got a job in a private school as a custodian. Now, when he appeared before us, the school closed. So even though he got the pardon, where do you go, 56, 57 years old, in with that burden? You know, and I thought of him and with his health background. And he had been so involved in his community. He has a wife and children, was involved in his church and in sports. He was a coach. He did everything. And I thought, you know, I have to believe when he went before that judge so many years ago, you know, 40 years ago, whatever, that that judge had discretion. Maybe he could have given him community service, probation, something. But that's how it changes lives in the minimum mandatory. So I understand it has to be very hard for a judge to know in your heart what you want to do, but you're not able to do by law. And it was a judge that challenged it. And I don't know what happened, what the repercussions of that was, but she did. But, you know, I want to just give you an opportunity to talk about some of the things we talked about and that I read over and over in your JNC questionnaire. Now, you had a case with Mr. Montero, and why don't you tell us about that?
The Montero case was a domestic violence case
Yeah.
over in Somerville that I had. That ended up being a bench trial. I was really fortunate because I had 2 pretty experienced attorneys. The defendant was represented by Joe Monahan, who is an incredibly fine attorney. That was a case where the couple were involved. They had a child. They were expecting another child, but this young lady, many times it's difficult to get people to testify in those sort of situations. I appointed an attorney because Attorney Monahan thought that the victim might have a Fifth Amendment. She didn't. She wished to testify. She testified. I found the young man not guilty of what are probably the 2 most serious charges, but found him guilty of an assault and battery, dangerous weapon, and assault and battery. The Commonwealth moved to have him placed on probation. Unfortunately, he violated the terms and conditions associated with his probation and ended up back before the court. I didn't handle the probation violation hearing associated with the situation, so I'm not quite sure what the outcome was in terms of that young man, but that was the Montero case.
The child abuse cases, God bless you, I don't know how you do it, but what was the most rewarding outcome of a case that you've had?
Well, the most rewarding outcomes of cases that I had, really, I would have to say, pretty much mostly existed in private practice, though I do see it occasionally as a district court judge. The
Well,
most,
you know what, all your experience, 33 years is not something you can throw out. 33 years, you were private practice. You worked for the sheriff's office, you worked for the district attorney. And what was impressive to me was you were an inmate, legal service attorney. What you learned to be in prison with these people, I mean, you have it all together. And so don't underestimate because you were an attorney rather than a judge. So I'm sorry to interrupt.
thank you. No, no problem. The most rewarding cases are where you prevent someone from having a criminal record, whether that's as a judge or when I was in private practice. If there is something that can be done that causes an individual not to develop a board of probation record, that to me is incredibly rewarding because they follow you around for the rest of your life and can cause employment problems, housing problems. So resolving matters short of having to have someone have a criminal record.
So, what do you see, they always call the district court the people's court. To go to the Superior Court's a lot of writing, and I know you for 9 years, and you love to write, and that's what we need. I learned that a judge, I didn't vote for him, but anyway, that the council had voted for, he had gone from the district court, and he came back, and they voted for him to go to the Superior Court, and I found out that he went to whoever is in charge to go back to the district court, too much writing. It was too much writing for him. So we went back to now he's retired. But tell me about your writing. I mean, that's something you're looking forward to?
Most certainly, because before I went on the district court, I did a lot of appellate work on everything from murder cases to armed robberies to manslaughter cases, all those sort of things. And those are those really complicated cases where trials lasted 3 weeks and you have to really analyze a record and put together the writing. And I very much enjoyed the writing and research associated with those appellate matters.
You know what? I think it's very important for you to have the opportunity to talk about all your voluntary pro bono work. I have never seen so much anyone with person, and you still do it. You still do it. And I am especially pleased that you have, for 10 years, you have worked to benefit people with disabilities. And I served on a commission of disabilities for 22 years. So I know the need, and we should have more judges, more attorneys that do dedicate themselves to that area of people that sometimes are overlooked, people with mental issues that you have been involved in. So if you want to tell us some of those things, I mean, you have represented the church, a community, kids. Why don't you tell rather than me saying it? And there's so many things that you've been involved in, 10 years, 5 years, and you're still doing it. And we kind of brush the aside that you have, these stuffed animals that you bring to a child. As a mother of 4, I know what that means to a child. And I mean, this is the compassion that I look for in a judge. So tell us all about what you've been doing for the last 10 years, and you haven't stopped. You're still doing all of this voluntary pro bono work.
Thank you. Well, I volunteer for Road to the Right Track, which is a running program in Boston writing for youth between the ages, usually about 7 and 18. We try to target at-risk youth where I'm an ex-officio member because I'm supposed to get involved in the financial dealings associated with any organization. And we are sponsored by the New Balance Foundation, and they provide us everything from clothes and shoes for the children and to entry fees into little local road races so that we can have those experiences there. And we sometimes have gatherings We had one about a month ago in the Faneuil Street Housing Development in Brighton, and we really just try to reach out into the community and touch upon individuals, children that might be able to benefit so that we can become involved in their lives and stabilizing forces to know that they have adults who care for them that they might already have in their life. So that's really kind of my current passion, but I've had that passion for different organizations for many, many years.
Right. Yeah, I mean, there's just so many other things that you have been involved in, but you're too humble to talk about it, I know. But, you know, I just, in the vocational.
They do job placement and training for special needs adults. That's the one where I brought my daughter in the infant carrier. I started volunteering with them when she was a couple months old, and she loved it too.
These are special needs adults,
Yes,
right?
that's true. And she used to come to all the meetings with me when she was out of her infant carrier and old enough. I used to take her to McDonald's and we'd get her a Happy Meal. She'd sit there. They made me assistant to the secretary because I was the secretary. And she and her brother used to volunteer at their fundraisers at the Spangler Center at Harvard every year, and they would give out the programs. And it was the cutest thing because the special needs adults loved my kids and my kids loved them. And it was an incredibly positive and rewarding experience for them to learn about the importance of caring for individuals who had those sort of needs at a very young age.
Well, you know, I could keep you much longer for all of the things you've done, and you're a runner. And I'm embarrassed to say that I walk from my house to my car, and I'm just amazed, and that's why you look like that. So you run 10 marathons. Yeah, are you going to run now in October?
Unfortunately, I'm not going to be able to run in October. I injured myself in February and into March, and I'm older and I need to respect my body. And I'm not at the point where I'm really up to running the marathon. I am registered, unfortunately, and I would have loved to have, but I'm going to be cheering Caitlin.
But amazing. I mean, even you're running Nova Scotia.
I did.
Unbelievable. But, you know, I can't say enough, you know, how pleased I am to see you after 9 years and for you to take the time, because people don't know that you get, as all nominees, you get a questionnaire from us, and it asks you to fill it out and send it in 8 days, at least 8 days before the hearing. Well, we didn't even have your name 8 days, and so you find out 6 days before, and you went back to the future, and you got it in, and we met. We got it in, and it was wonderful. I just to fill out the last 9 years, and I couldn't be more proud that I voted for you before. And I will again, and I just thank you, and I wish that the administration would stop looking at people your age with your outstanding background. We need that. We don't need someone with six cases and 21 years ago the Superior Court. Superior Court is not a learning place, not a learning place. And I'm so confident that you know, that whole expression hit the ground running. I'm so happy. I've been smiling since I saw your application. So anyway, thank you so much.
I expect Council Iannello is not going to have a lot of questions. The only one he would probably have is the Boston Latin question. I think that was enough for him that you graduated Boston Latin.
Chairman and councilors, I'm terribly sorry. May I be?
Yes, of course. Yeah, I just want to say before you leave, you should be the happiest person in the world when you get it, okay?
Thank you.
Council Iannello.
Graduated from Boston Latin a few.
Just a bit.
I love Boston Latin. I thought it was a great school. I still think today it's one of the finest public schools in the country. I'm a strong advocate, if possible, and under the right circumstances, for rehabilitation as opposed to incarceration. And from what I hear from
Here.
I hear you agree with me. I would believe that you agree with me on that.
Totally. I think that it's incredibly important, and as you well know, whether you're in the district court or the superior court, 99% of the people who are going to the court are going out back into the community. And if we don't give them skills that help to rehabilitate them, we're doing a disservice, not just to them, but to our community and to ourselves.
Totally agree. I love your statement when you said one of the most important things you've done or believe in the district court is preventing someone from getting a criminal record. And that's really good. I think that is admirable. I'm a believer in giving people second chances, so I like that. I mean, clearly you have the right temperament, the character, the experience. You seem like a compassionate person. And to top it all off, you got Bob Rufo. I've known sheriff, judge, whatever you want to call him, for quite some time. And I remember when he ran for mayor of Boston, I was in his corner. At that time, we both have something in common. We lost that age. Oh, man, I'm still working every time. But no, next week, we had a nice conversation. You can count on me next week.
Thank you. Councilor Duff?
Oh, can you hear me now?
Yes, go ahead, Councilor Duff.
Great, thank you. Yes, I concur with the previous councilors. This is an excellent nominee. I do have a few questions, though. We did have a good talk, which I appreciated your time. And as you know, we discussed, I come from an old school classic liberal arts education. So your writing was of utmost interest to me. And I think Councilor Devaney asked you, but I'm going to ask you again. Did you say that you do enjoy writing?
I really do. I did a lot of appellate work, especially when my children were younger, because it allowed me flexibility in my work schedule. And I really enjoy the challenges associated with researching the issues and doing a lot of writing. Yes, so I'm very much looking forward to that in the Superior Court. Even as a district court judge, in almost every single case involving a motion to suppress that came before me, I issued a written decision associated with that. I did not just issue a verbal decision. I thought it was important to the attorneys and their clients associated with the cases.
Thank you. And I know that you appreciate the nuances in words, and particularly words in the law. I think many of us read the front page stories today about a case filed yesterday where the wrong language was used, and it's quite embarrassing to the attorneys who filed it. And that is what I say the difference between writing and knowing how to write and knowing how to read and write. Anyway, the thing that I really wanted to talk to you about, and it was touched on a little bit, is your experience either in the courts or in life of implicit bias. And, we are, this entire group, privileged white folks, who've had different lives and different opportunities. And as you said something in your introduction, as people who have a lot should be expected of us. And I truly believe that. I believe in the old school public service. We're here to do the right thing and to hold people up that need help. That's what the public has entrusted us with. And yet at the same time, one of your witnesses said to also be just, which is that was a tremendous speech she gave. Really a wonderful use, again, of words and what words really mean. Would you share, if you're comfortable, with us any experiences that you may have had either in the courts or in life of prejudice or bias or anything that you may have ever observed with somebody and how it may have impacted you? Or was it shocking? Did you think of it? Or have you ever even experienced it?
Thank you. Well, One thing that really sticks out in all of my history is that when I was in law school, I dated a Black gentleman who was in law school over at BU, and he lived in Alston. And I thought I was pretty with it because I grew up in the city of Boston. I had a very diverse friend group. And he asked me one day, he said, "Kath, will you come into Copley with me so that we can buy a present for my sister? Her birthday is this weekend." And I said, "Sure, of course." We were on the train going into Boston, and Brad said to me, he said, "Kath, I want you to watch the way that people treat us when we go into the shops at Copley. They're going to treat us differently because I'm Black." And I said, "Come on, Brad, that's not going to happen. That's not." He says, "Do me a favor. When we go in, I just want you to gear into it, and I want you to watch." And so we went in, and we went into a jewelry store, and all eyes turned on us. Everybody who worked there was white. They all looked at us. And you could tell they were just watching us. And I was like, well, that's just one store. We went into the next store, is upscale boutique for women. And they put an undercover person on us that followed us around the store while we were there. And if we went into 6 stores, and at least 4 of them, the exact same thing happened. And we ended up leaving Copley. And I said to Brad, I am so sorry. You were 100% right. I was 100% wrong. I am so sorry. And he said to me, "Oh, it's not really that big a deal." And I said to him, "No, it is a big deal. It's a really big deal." And for a moment in my life, I felt what some other people feel every single day. And I have never, ever forgotten it. And when Judge Ireland wrote about driving while Black, all I could think of was that experience that I had with Brad, and how those things really do happen, and how there are just injustices in society that affect the way people perceive others. And it hurts me that we are 30 years plus of that experience that I had with Brad in Copley, and we have not made the strides associated with those situations that I wish that we did as a society. But it really has kind of guided me in the way that I look at things, so that I'll take a variety of different perceptions and perspectives into consideration in trying to understand a situation.
Yeah. Thank you for sharing that very personal story. It, I've had similar experiences. I come from a multiracial, multi-ethnic family, but I also went to college in a city where I was in a minority. So to learn the experience of feeling other at a young age is profound. And the reason it's implicit bias is because we don't even recognize it in ourselves. And even you and I, who may think we're evolved or anything else, we still have our own implicit bias. It is human nature to do that. I think the thing that's hard for us to acknowledge is that we have it, because then we feel somehow it's a moral failing. Whereas I see it as more, we need to acknowledge it so we can do better. Thank you very much, because I think this is, we don't not only know that this is an issue nationally and in the Commonwealth today, but really profoundly in our courts. And so just acknowledging it and being aware of it and being willing to speak about it and admit that we have some faults will help us get better. With that, the only last comment I have is Counsel Kennedy has been relentless in how terrific you are, and incredibly qualified for this bench. Now, Salem's part of my district, and everyone there thinks, you're the second coming of Christ. So between Kennedy and my constituents, I think, I don't usually say, but I think I'm probably going to have to vote for you. So, but you will be a fabulous addition. And thank you, one, for your service to the Commonwealth, for stepping up. People like you could make a lot more money in private practice. I appreciate the sacrifice that you've made, and I appreciate your service. So thank you very much. That's all I have to say, Mr. Chairman.
Thank you. Councilor DePaulo.
Thank you, Councilor Kennedy. Good morning, or good afternoon. We didn't have a chance to talk ahead of time, and it was entirely my fault, so I apologize. But from some of your earlier comments, I can tell you did your homework, so you probably know what I'm going to ask. I think it's great that you have an extensive background in prosecutorial and defense work. I think that's a great balance to have. Right now in the Superior Court, we have almost half of our judges have exclusively prosecutorial experience, 46%. That's 3 times the defense representation there with exclusive defense. And then we have about 15% have both. Do you think that's a good balance? Have 3 times as many prosecutorial attorneys, pardon me, former prosecutors as opposed to former defense attorneys?
Because I think that it's important to have a variety of different perspectives. Everyone, based upon their life experiences, brings something a little bit different to the table. And I think that it's important to try to strike out balance associated with anything in life. Everyone, and that's why one of the things that I love about your website and the things that you say is how important it is to try to seek diversity for our courts, because everyone, based upon their life experiences, has experienced things in a different way. And it's my opinion that every voice deserves to be heard associated with a situation, and the only way that we get there is through having people with diverse backgrounds on the court. I know that sometimes even I've watched, and I know that there are mixed feelings associated with some of the young individuals who are minorities that we bring into the court as judges. They're young. Well, we have to get them when they're young, because if they're quality people and they can do a good job for us, they can make so much money in private practice because there's such a demand for them. So you wonder why people with these diverse backgrounds end up getting plucked and brought before you when they're at a young age. It's because if you don't get the good ones then and you don't bring them into the courts, they're going to make so much money in private practice that many of them aren't going to want to do the work.
Another thing I notice is qualified minority candidates sometimes not even thinking to apply or finding or assuming that the barriers would be too high. So I think that's an important reason. I think as a judge in district and potentially superior, that's important to be mentoring and female attorneys too, because we're not there yet either. And that's not this administration, that's kind of the trend total. That's been past administrations as well, with an overwhelming prosecutorial. So access to justice is really important to me, and that includes making sure folks are comfortable in the courtroom so that they can get their experience out. And so the anecdote of, having a comfortable place for children who are coming into the court really resonates and says a lot to me. Counselor Juneville talked about sentencing guidelines, and I agree with most of what he had to say. And you mentioned the mitigating factors, and I just want to use a couple of those as a starting point. So the defendant was suffering from a mental or physical condition that significantly reduced his culpability for the offense. Do you think PTSD fits into a mental condition, post-traumatic stress disorder?
Traumatic stress disorder is a mental condition. I agree that is true and accurate, yes.
And you've dealt with a lot of victims of child abuse, or you've dealt with cases involving child abuse?
Certainly, and one of the other things in private practice, I will tell you, 85% represented in commitments associated with substance abuse had been sexually abused. At least 85% of them had.
Yeah.
And
we're building a new women's prison potentially.
We should be building a new women's treatment facility because there aren't enough beds for women who have substance abuse issues and who suffer from mental health issues. Not a prison, but treatment facility. That's my opinion associated with that particular situation. And one of the things that I've seen us come forward a little bit more about is the need for dual diagnosis treatment. You can't just throw someone into an addiction clinic and treat the addiction, because if you don't find out what the underlying issues are associated with that individual's background, you're never going to give them the proper tools to be able to overcome their addiction. So we have begun to move in the direction of dual diagnosis programs, and almost all programs at this particular time now have mental health individuals on their staff. That was not the way that it was when I was in private practice. They thought you could just throw someone into a addiction facility, get them to sober up, and then they were going to be good. And that is a recipe for disaster.
I've worked in therapeutic high schools where I'm trained in restraint because I have students who manifest serious trauma. And I've had students who I'll restrain in the school setting, and we have restorative justice practices, et cetera. I had one student who had turned 18 recently, was having a manifestation of psychotic episode at their home. Her mother called the police. She was arrested for assaulting a police officer and resisting arrest. And I can't imagine being a parent and wondering, what am I going to do right now? Do I call the police and risk involving my daughter in the criminal system? Back to the sentencing guidelines, mitigating factors. The age of the defendant, you've convinced me that you have an understanding and a sensitivity to brain development that's important to me. The defendant's residence in a poor minority area. This has been touched on by a couple people, and you were apt to note that the sentencing disparities happen in Superior Court. And that may begin in communities, it may begin in the sentencing phase where concurrent jurisdiction, you're twice as likely if you're black or brown to end up in Superior versus District, and of course you're exposed to higher sentences there. In Superior Court, when we look at things, and you talked a little bit about implicit bias, in particular when we look at charges, drugs and weapons, it's huge. It's like 128 days when you factor in all the contextual evidence we can find. Why drugs and weapons? Why are we so intent as a Commonwealth to give black and brown folks heavy sentences on drugs and weapons?
Well, you've hit one of the two areas of, other than for like murder, where they have imposed minimum mandatory sentencing in weapons and in drug cases. And anyone who looks at those policies knows that it had a huge adverse impact on minority communities. I mean, I live in the city of Boston. I'm a judge in Chelsea right now. You could throw a stone and hit a school on every corner.
Right.
It's not that way in the suburbs, and therefore there's a tremendous adverse impact. I do blame some of the situations associated with sentencing on the development of minimum mandatories, which have led, because sometimes minimum mandatories become a negotiating tool, right? The Commonwealth uses them in order to get a higher sentence on another charge. They'll say, oh, we'll get rid of that. But your client, for us to do that, because that's a charge reduction, or it's we're going to get rid of something, you have to enter into this agreed upon plea associated with what your client's going to take. And that is, in my opinion, sometimes what could be a factor in play in causing higher sentences for the weapons and drugs and the disparities associated with those. But that's where, you know, the Harvard report helped us to see the interplay between the whole entire system, right? You're charged with something, and that just the charge itself can have an adverse impact on the outcome of the case. You know, it helped to expose some of those things to us.
And for me, you know, all the talk of implicit bias going on, I mean, that's fantastic, but that's the human trait. That's not particular to race. And so, you know, I think these conversations, especially among the judiciary, I hope they continue, because I don't understand why Massachusetts has the highest Latino incarceration rate in the country and the 14th highest Black incarceration rate in the country. I think that would surprise most folks in Massachusetts. I don't think Latinos in Massachusetts are more criminal-minded than Latinos anywhere else in the country. Given that we know about the injustices of mandatory minimum sentences, about the disparities in sentencing. Do you think that commutations would be an effective, immediate, and targeted tool to remedy some of that?
I think that we really need to do more in terms of commutations. I was very happy with the article the Boston Globe wrote yesterday associated with Devin McCourty coming forward and speaking on behalf of that gentleman, William Allen, who was a joint venturer under the law anyway, associated with that particular situation. And it pains me that we do not do more in that particular area, because I do think that it is a tool that could be used to help to balance the system out a little bit more.
So 2 and 6 years seems low to you for commutation hearings.
I'm sorry.
Out of hundreds of applications, the parole board has held 2 commutation hearings in the last 6 years. That sounds too low to you. Yeah. Your work with inmate legal services, you were in county jail, I assume, a lot for that?
I was.
And have you been in Department of Corrections facilities as well?
I have visited every house of correction in the Commonwealth of Massachusetts when I was on the Massachusetts Sentencing Commission, because I was in charge of helping with getting all the data from all the sheriff's departments. And we also went to visit. I don't know if there's a DOC facility in the Commonwealth of Massachusetts that I haven't visited.
Have you reviewed the Trump administration's DOJ report on Massachusetts Department of Corrections?
Are you talking about the issues associated with the mental health?
Yeah, the assertions of violations of inmate civil rights regarding access.
I have not looked at the whole entire report.
Okay.
It was your website that kind of linked to that, but that's an incredibly interesting.
Thank you for the website traffic. It sounds like to check my analytics. I thought they were potential voters.
That's an incredibly interesting issue, because during the period of time that I was in private practice, as you may know, the old colony facility became a facility that was supposed to specialize in mental health treatment of individuals. But I'll tell you, even as a private practitioner, on 2 occasions when I went to visit clients in the House of Corrections, they were suffering from severe mental health breakdowns. And I had to get the individual in charge of those facilities to do a commitment on the individual. I was there, and I had one client who was rambling on with sexual statements and things, and he couldn't even concentrate. And there is a lot to be desired in terms of mental health treatment associated with that. And I had another gentleman when I was an inmate legal services attorney at the jail who had just the most severe mental health issues that you can imagine. And unfortunately, sometimes someone has to step forward and bring that to the attention of the powers that be within a facility to get something done about it. And that's one of the reasons why, as an individual, when I was in private practice and I was representing defendants, I would never, ever, ever allow a client to come before the court if I had not gone and visited them in the facility before our next court date. And that meant, I would go sometimes a ton of times. And I remember even one time when my kids were little, showing up at, I could have been MCI Concord at like 10 or 11 o'clock at night, because I didn't have childcare and I didn't have anyone to watch them, or one of them was sick. My client was going to be coming in the next day, and I would never, ever allow my client to come before the court without having gone to see them before we went in front of the judge. So, but, that I'm kind of getting a little bit off track associated with your question. So I apologize for that, sir.
No, it's okay. I mean, you raise the important points. I mean, it's bad for our prisoners. It's bad, I think, for our corrections guards, and it's bad for our communities, because we're spending $70,000 a year to lock these folks up when what they really need is mental health counseling. I have no further questions. I'm really impressed with your perspective, and I appreciate your time this afternoon.
Counselor Hurley. Come on.
Can you hear me?
We can.
Okay, thank you. I just have a few questions. From your perspective, being in district court, I was there too. We served an overlapping period of time. But now you're going to Superior Court, and the types of cases that are going to be before you are of a much more serious nature. Are you prepared to hand out sentences that fit the crime, that acknowledge the harm done to the victim, and that will best serve justice?
Well, one of the things that balances out my experience as a judge in the district court is really my appellate work that I did for the Committee for Public Counsel Services, because I was on their murder list, and I also mentored other attorneys that were doing appellate work for the Committee for Public Counsel Services. So I have a tremendous amount of experience with life felonies and with very, very serious matters that have brought people before the Superior Court, also in private practice. I had Superior Court matters in Norfolk, Suffolk, Essex, Middlesex, and Dukes County, representing individuals privately on a variety of different cases. So I think I'm pretty familiar with it, and I certainly will give every case that comes in front of me the individual analysis it should have in order to impose the appropriate sentence given the facts and circumstances.
What would be the analysis in a case where someone is a young lady living by herself in an apartment, and her apartment is broken into and she's raped? And that person and she do not know each other. He's got a prior record for some violent offenses, and he's now before the court as a result of DNA evidence and an identification by her that this is the person that perpetrated the crime that's going to affect this woman for the rest of her life. All right? What would you think is an appropriate sentence? The Commonwealth is recommending 25 years, and defense counsel is saying 3 years. Based on those facts and circumstances, what would your analysis be, and how would you determine what the sentence is that you would give, and what would that sentence be?
Counselor Hurley, I can't answer it with complete clarity, but there are a few things that would really be important to me to know associated with the case. And that is, I would want to have in advance of developing a sentence that's appropriate in that situation, a victim witness impact statement. If that individual wished to be heard by the court, I would want to hear them on that issue, and I would try to take those things into consideration along with other factors to come to what I thought was an appropriate sentence under the circumstances. Certainly, I don't think that 3 years or 25 years at either end of the spectrum is probably an appropriate disposition associated with the case, but there could be a lot of other facts and circumstances that I might like to take into consideration, which would help to guide me to what I thought the appropriate number was.
Well, what does your gut tell you?
My gut tells me that the guy probably deserves somewhere between 10 and 15 years, but I don't know because there's so many variables that come into consideration associated with something like that. And so I cannot say that with certainty, but my gut tells me that, having looked at probably thousands of criminal records and done analyses associated with cases, but I can't say for sure.
All right, thank you. And in terms of the Superior Court's authority to review bails set by district courts, what do you think about that?
And as you know, I think I do a wonderful job making determinations associated with bail, so I don't like what I've done being reversed by the Superior Court. But sometimes it is good to get a new set of eyes associated with a situation. One of the things that drives me absolutely crazy about that whole entire policy is, though, that if the Superior Court decides someone should be released on a GPS with conditions and other things, it's thrown back on the district court associated with the situation. And then there are issues that come up, and they don't want to go back in front of the Superior Court judge, and they want us to deal with the situation that's before the district court now, based upon their change in what we have done under the circumstances. So I will review them appropriately and try to make the right decision. I have a lot of faith in my colleagues in the district court. There may be some disagreements associated with that, and if I thought so, I wouldn't hesitate to indicate what my disagreements were.
Well, as a resident of Hampden County, I can tell you that an all too liberal Worcester County judge came to Hampden County and released someone on an appeal. A Superior Court judge released someone on an appeal from a district court order and put that person on a bracelet. And he turned out to be a serial killer that killed 2 women and brutally beat and tried to rape and kill a 3rd woman. So I guess my message to you today is that the stakes are an awful lot higher in the Superior Court than in the district court. And to the extent that the district court is a court of second chances, the Superior Court doesn't allow for that anywhere near as often. Do you agree with that?
Yes.
You have a great reputation. Counselor Kennedy became almost obsessive with saying great things about you. Oh, he was obsessive. Let's be honest. And I think that you've got it all together.
You're giving away my vote, Mary.
What? What?
You're giving away my vote.
Your vote for this lady was given away a long time ago. Trust me. But I think you're going to do a great job. I think you got a good sense of balance, and you know, the victims in Superior Court, their cases are so much more tragic and so much more a situation where the impact of the crime on them must always be taken into consideration. So I thank you, wish you good luck, and I think you do a great job.
Thanks so much. Thank you.
Thank you, Councilor Hurley. I will have a comment. I actually spoke with Judge Dreschler this morning, Superior Court, and I told him we were doing your hearing today. And he actually commented on the fact that it was very rare for one of your bills to get overturned. That usually when the 58 days came up, they were usually withheld. And he disclosed that a lot of times it depends on who the judge is that's setting bail is when they look at it, because obviously some people get overturned a lot more than others. Some people are harder than other people on bails. Obviously, it's no secret where I stand on this, because I encourage you to apply. I'm happy you did. What was your answer when I asked you?
No.
No, that's right. Yeah. And I'm happy you changed your mind.
We'll help with that.
I'm glad you changed your mind. And I talked to you about the need for getting some very smart women on the Superior Court. And that's something nobody's addressed. And at one point, I think we were up to 35 or 38% women on the Superior Court, and we're down around the 20% mark. So for all of those reasons, I'm really happy that you applied, and I am going to be very excited to put your name in up for a vote next week. And you can guess my vote. Okay, we'll adjourn. You're done. We'll see you when you're with your SJC application in a couple of years.
Thank you.
I'm so sorry about what happened this week.